Thank you, Mr. Chairman and committee members. We are before you with a bill that's been a number of years in the process. And it started about, I think, 5 years ago, if I'm correct or not. It was the first young lawyer section of the state bar looking at really just doing a re-indexing and redrafting of the current law and trying to make it more easier to follow and read. From that, it's grown through the years more and more changes of what we call policy and recognizing things we were doing as a way of practice in the juvenile arena as far as juvenile justice has not been sometimes the best approach. And I think that's evident by what we've had, not only the numbers who've been incarcerated, we'll say, in a lockup situation, but also recidivism, which has been extremely high, I think, in that area. We're approaching 65% of those children who have been taken into custody by juvenile justice coming back within 3 years, some other form of either juvenile justice or senior adult criminal conduct. What you have before you, and I want to say, I've said before, I say it again, I feel like the poor boy in the wagon. So many people have been pulling this wagon, and I've just been the one taking a good ride with it. So we've had a lot of work, a lot of interest groups been directly involved, working with the committee, working with me, working with Jill Travis and the governor's office. Thank goodness the governor's office became concerned about this from last year and had conversations with the governor and staff regarding the bill we were putting through last year and wanted to say, hold up, we weren't sure about some measures we had in there, what may be involved as far as potential costs either to the state or to local governments. And so even though the bill had passed the House, we agreed, let's hold it up and let the governor look further into it. And the governor took the initiative to have a continuation of his commission looking at justice reform and charged them with reviewing the laws of Georgia and procedures we have in Georgia on juvenile justice. And I know there will be some people speaking to you after I end addressing the work of the commission. I served on it. It was a very rewarding experience. We had a great deal of information coming in from not only interest groups, but also two bodies that provided financial support, and that's the Pew Institute as well as the Anna B. Casey Foundation, both of which have had a great interest over the years in the juvenile justice throughout the country. So they came in and did a lot of wonderful work for us, looking at statistics and information about how and why we have young people in our juvenile justice system. I say that for a background because although the bill incorporates a number of things addressing the policy changes, we also recognize a lot of this is going to be done through the administration, the governor's office, and his various departments. And we've had input through the community health department, the behavioral health department, juvenile justice department, DFACs, all of which have joined in to look where we can make these policy changes that will make a better system for us. So I want to preface my comments about the bill with some of that background for the committee. Mr. Chairman, the bill is a big bill. It's 248 pages, I think it is, 247. It's one of the biggest bills I've had to work with, maybe bigger, almost as big as the evidence code we did a couple years back. But I want to publicly comment and commend Ms. Travis with the Legislative Council for the fine work she has done throughout this process. I don't think the thing we have as a product to be as well done without her input. So for the committee's benefit, I'd like to recognize that. Besides the bill that's before you, and I'm not going to go into a lot of the detail unless the committee wishes to do so, but we do have and have brought before the committee a document AM 2165, which are a list of amendments. And what's happened is this. We had further input, for instance, from the juvenile judges recognizing that some of the timelines that we placed in the bill by which they were to conduct hearings may not be as reasonable as we need to be with them, because there may be times where a child is brought into a custody situation and it will be a Friday evening, Saturday, Sunday situation. So rather than calling for these hearings always to be held within 24 hours, we try to recognize that and gave them up to a period of time. So if there was a holiday or weekend, it extended the time. And what I'd like to do, if you've got your amendment before you, Mr. Chairman, if you wish, I'd be happy to go through and give you some information regarding what the amendment addresses and why it's suggested we do this. If you look at the, I'll go by line items. If you look at lines 1 to 9 of the amendment, it includes language which clarifies the fourth prior delinquent act committed by a juvenile will be a Class A felony, but that the minor offenses such as status offenses are not counted as delinquent act for this purpose. So you can accumulate a number of what we call status offenses, and they're not necessarily going to be always requiring a judge to take action. In fact, it will prohibit the judge to do something as far as a lockup situation on these types of offenses until there's accumulation of a certain number. Lines 10 and 14 of the amendment include language that came from a House Bill 369 related to termination of parental rights in limited circumstances of a legal father when a biological father is also a party to the case. This language came as a suggestion from the Supreme Court in its holding of Bryan versus Schiff. And although the bill was traveling forward through the House, Chairman, members of the committee, we had two other bills that I directly was not aware of until they came through the Rules Committee, and I saw the bills there and said, oops, we've got something here that is dealing with our House Bill 242, and I didn't want to pass those bills out. And so what we decided to do is let them come forward to your committee, to the Senate, as potential amendments. So that is why we're having information coming out of two bills. One is House Bill 369, the other is House Bill 219, which I addressed at lines 15 to 21. This amendment includes language from House Bill 219, which allows in limited circumstances the modification of a delinquency order if the offender was a victim of trafficking or sexual exploitation. And we thought that needed to be best addressed in the bill as opposed to the separate amendment. Next, we have lines 22 to 34 of the amendment that clarifies existing law relating to court's discretion in certifying certain expenses. Existing law in HB 242 requires a court to certify expenses in certain circumstances, and this language provides factors for the court to use in making a certification determination. Line 35 of the amendment appropriately numbers a code section, which we had misstated. And line 33 to 37 corrects a typographical error in House Bill 242, including the word parents, and that was inadvertently omitted. Line 38 to 43 change at the request of the juvenile court judges and county governments the requirements addressing children in need of service hearings within 24 hours and subject to, as I mentioned earlier, that's one of the major things we were looking at in several places. This is one of them. Line 44 to 47 clarifies that a CASA, that's a court-appointed special advocate, may act as a guardian ad litem when and whenever possible. Lines 49 to 54 change at the request of juvenile court judges and county governments the requirement for a child in need of service hearing within 24 hours to begin to 72 hours. Line 55 to 58 is to clarify again the case may act as a guardian ad litem, as I mentioned earlier. Then lines 59 to 60 corrects an error in the original bill that included terms that were not appropriately defined. Line 61 to 65 restores the language from last year's House Bill 641 regarding the transfer of certain sex offenders back to juvenile court. That was, again, something that was omitted, but best to put back in here. Lines 66 to 75 simplify and clarify the language regarding the disposition options available to judges for punishment of Class B designated felons, but it does not change the substance of the bill. I think you will hear from some individuals who served on the commission with what we're talking about as far as Class A and Class B felons. We have addressed a difference here between those type of felony charges because we want to have the court given discretion, which it did not still have under the current law. Line 77 to 86 also includes that language we talked about from House Bill 219, which allows in limited circumstances the sealing of delinquency records of an offender who was a victim of trafficking or sexual exploitation. Lines 87 to 88 appropriately renumber a code section. Line 89 and 91 slightly changed at the request of the prosecuting attorney's counsel the process by which a district attorney can reclaim the prosecution of a juvenile case that was assigned to another attorney by court appointment. Lines 92 to 107 includes language from House Bill, again, 369 relating to termination of parental rights in limited circumstances of a legal father when a biological father is also a party to the case. This, again, was language suggested by the Supreme Court in that holding of Bryan versus Shipp. And lastly, the lines 107 to 111 changed the implementation date of the law from July 1st, 2013 to January 1st, 2014. Although all of us want to have these policies implemented at an early date, Mr. Chairman, we realize there's going to be an education process, not only to judges, but to the trial practitioners around the state, as well as departments, as to what their duties and responsibilities be. So we think it's best to give a little more time, leeway to be prepared to understand all of this and have seminars. With that, Mr. Chairman, I'll be happy to